Good afternoon, everybody. This is the webinar for Options for Artists and Entertainers. My name is Fuji Whittenburg. I'm an attorney with Wolfsdorf Immigration Law Group, and I welcome you guys all to the webinar today. Thanks for joining us, and thanks for registering. Just a couple of quick items I wanted to go over before we get started. Hold on one second. If you'd like to register for additional webinars, we have them at our website. Whenever you have time, you can register for future webinars. And after this concludes, what we'll do is, I think it takes some time, and then the webinar will actually be posted online at our website, and you can listen to it again. And then the way this is going to work, I'll basically run through the visa options, visa and green card options, and then at the very end, if there's time, I will try and answer some questions. But definitely, please feel free to, email me. I think there's a chat function here on the webinar, and I'll be able to access these afterwards. Or you can email me, and at the very end, my email address will pop up. But just in case you want to write it down now, it's my name is Fuji Whittenburg, and my email address is fwhittenberg@wolfsdorf.com. It's also on our website. Feel free to just email me any questions at all, and I'm more than happy to take some time to give you a quick response and then see if there's any way that we can help. So enough about that. This is our a service that we provide, our law firm, and we welcome you to join future presentations. Now let's get started. visas. For those of you listening, I'm assuming most of you are in the arts and entertainment field, which is more specifically what this specific webinar is going to cover. The O visa category, there are two classifications. There's the O1A, which has a higher standard, and that's for sciences, education, business, or athletics. And then there's the O1B, so that's for people in the arts industry, so artists, musicians, graphic designers, visual effects artists, and then there's motion picture TV. So there are two subcategories under that particular category, and we'll go through them a little bit later, and the requirements are slightly different. And one particular note I wanted to throw out there, fashion models, I do a lot of models, they do fall under the higher standard. There was a case actually many years ago a Ford Models case where it was held that fashion models are held under the business standard. So that's something kind of interesting. And then some other classifications other than the O1, if you feel like you don't quite qualify for that, there's the O2 visa for essential support personnel, which would be tied to an O1. So for instance, if you are an assistant director and your credits aren't quite there, if perhaps the director that you worked with, he qualifies and is on an O1, he qualifies, then you may be able to apply for an O2 linked to that O1. The next one is, independents, they qualify for the O3 visas. I've listed here the different standards for the three different categories. The O1A has, as I said, a higher category or a higher standard, and you have to show you're one of a small percentage who has risen to the very top of the field. In the middle there is the arts category, which is again, musicians, graphic designers, visual effects artists, and then the third category, just under that, is the film and TV. They do have a slightly lower standard, and then also they require consultations. But basically for film and TV, it's a high level of accomplishment, and above that's what is ordinarily encountered. So there's a range there. Basic filing procedures, I'll run through that. It's there, as with every petition, there are forms. There is a support letter that comes from the sponsor, and then with the O1s, you really have to show some sort of a contract or an engagement of your services. So for a lot of people, for instance, in the entertainment industry, in terms of having an agent or a manager, this would be your kind of representation agreement that you would have, and with the petitioner, and then in addition, you'll have to have evidence of some jobs or work or productions that you'll be involved with. Some other, things to factor in if you're filing at the California Service Center versus Vermont, that is based on the location of your employment. So you have to, and if you are working all over, it's really based on the location of the petitioner. So if you're in Los Angeles, like we are, it's California Service Center. If you're, on the East Coast, it's Vermont. Recently, the processing times have been about the same on both coasts. And in terms of, a lot of people tend to say that Vermont is, nicer or easier than California. In some respects, maybe, but in others, I haven't really noticed a difference in our practice. And I'd like to think that's because we produce quality work. But, as the two offices do communicate, and hopefully they are kind of adjudicating petitions using the same standards, so they should be pretty consistent. The consultation requirement is actually really big in the O1, especially with O1 entertainment visas, so that's something to be really aware of. For instance, if you're an actor, you're required to get a consultation from SAG and AMPTP. If you're a musician, you're required to get it from the American Federation of Musicians and AMPTP, and then, it kind of goes along those lines depending on your particular field. So it's very, very specific. Some don't have, outside of entertainment, for motion picture TV, you're required to submit them. In the other fields, in the arts industry, if there is no, particular organization, then you would get a peer consultation, so a letter from somebody else in the field. The evidence, there are some criteria that are laid out in the regulations, and I cite the regulations here. And another requirement is a petitioner. I think a lot of people misclassify the O1. It's not necessarily a freelance. They think it's a freelance visa where all you need to do is just get an O1 with somebody and you can kind of work for anybody. That's not necessarily true. It's true in some, if you have an agent and things are done through your agent or manager, and those projects are included in your initial itinerary, and then, you are allowed to add subsequent events to your itinerary, but it's something where, it's very employer-specific or petitioner-specific, unless you have the agent manager petitioner. Deal memo or contract, again, you have to show that you have something. They don't, USCIS doesn't like to see speculative employment. They don't want to, give actors or models O1 visas just for them to come over here and go on auditions. They want to know that you have at least, some. Obviously, auditioning is part of the industry, but you should have at least, a couple of projects secured already. So, which standard will apply? A lot of times people ask, how do you figure it out? Especially today, people do. They write, they produce, they direct, they do all sorts of things. I actually just heard of this new, the new term predator. It's for a producer, writer, editor, I think. So you just want to, kind of narrow the field as much as you can, and then also look at the person's credits. What are they most, and that would be, the individual, or to you, just look at your credits. If most of your credits, maybe your passion lies in writing, but you've been producing, well, then it's probably better to file the O1 as a producer. So you really want to look at that. And then also in the same vein, I have somebody come to me as a producer where really they produce commercials, television commercials, and that's kind of its own little separate world. Being a commercial producer, it's that way. If you're specific about it, sometimes USCIS won't, ask for other things. For instance, that they would have a producer, which normally implies film. I think USCIS sees producer, and they're going to think film producer, and a commercial producer does, vastly different work. I've listed the standards here. We don't need to read through all of them, but you do need to show either the receipt of a major award or at least 3, and they list a bunch of criteria. And this is, I've listed here the sciences, education, athletics, business, and again, since this is arts and entertainment, I won't go through it too much, although for models, they do fall under this business category. So what I normally include would be, the person's tear sheets. So that's the published material. Some models in their home country have some press and interviews about them, so we would include that. And they are pretty strict about the evidence having the name of the publication as well as the date on the bottom of the tear sheets, or if it's a cover, for instance, if you are making copies or keeping copies for yourself, and I advise you to keep everything, you would want to make sure at least the name and the date of publication are on there. If you've worked, and again, this is very specific to models, but if you've worked for certain clients, you want to make sure you keep copies of those ad campaigns, any contracts that you receive, because another one is high salary, which, you can show through contracts, tax returns. A lot of people don't, have tax returns, or, so pay stubs. And then we've even gotten letters from agencies saying, this is to confirm she's gotten paid X for this project, X for this project, and so on. So you can do that, and then really it's tear sheets, letters, high remuneration, and work for big companies. Reference letters is something that applies. You can use letters to meet several different criteria sometimes. So it's really important to get really strong letters if possible, and then also, the bigger the name, the better. So the more prominent, the person, the better. And it's good to have a wide variety of letters from people, both that you have worked with and that you haven't worked with, who are in the U.S. and outside of the U.S. And that's something that you would, obviously work with your attorney or whoever, to get those. In terms of arts, so motion picture TV, they all, it's a slightly lower. The criteria are slightly different. Rather than, I'll flip back to the last one. There are 8 criteria here. This one has about 6. And so it's really all about your credits. I mean, if you look at it, it's really about the credits, the companies you've worked for or with, and then the productions themselves. So let's say, for instance, you're in, in TV. It's the TV shows. It's the network or the studio that produced it, or any nominations or awards that you've received, peer letters, and then press, like reviews that the show has received. Or if it's a movie, if you have worked in, possibly you have a lot of short films, for instance, and they've done particularly well at international film festivals. Those are the kinds of things that I, try and highlight, and I think is helpful. So it's really important to kind of look at absolutely everything you're involved in, and seeing how you can really highlight that and kind of draw out how important those were. So, a film festival, maybe your short film was invited to be screened at that film festival and was given, a particular honor. Those are the types of things that you would want to really try and highlight. And again, with press, if there's a review of your performance in particular would be amazing. But even if it's just a review of the film itself, we tend to try and include that in it, where hopefully it's published in a lot of places. So really, but the important thing is not just saying that those things have taken place or exist, but really that you can properly document it. So you want to have evidence. So if I say that she starred as, in the lead role in this film, and it was at this film festival, if there's no way of proving that that film screened at that film festival, or that you were nominated for Best Actress for that film at that film festival, then it doesn't really carry very much weight. So you need to evidence everything. We try and include as much as possible, and you try and meet as many as possible in the hopes of satisfying at least 3. So this brings me to my next point, which is who should be the petitioner, and this is everybody's biggest question, especially in arts and entertainment, where again, mostly, you're not actually working for anybody. You're being represented by people, but it's not, it doesn't have that classic employer-employee relationship. So it can be a little difficult, but you just need a petitioner. So your visa is limited to work through or with that petitioner for within this category, let's say you're a chef at a restaurant. That's a classic full-time situation, or a visual effects artist with a movie studio, you're with DreamWorks or something. That makes sense. But for those of again, everybody else, musicians and actors, actresses, most people have a different situation. So if an agent is your employer or your petitioner, you do need a deal memo and a contract that detail the specific terms of the representation. So are they your exclusive manager? What kind of, and that's actually pretty detailed already in most contracts in existence, so it doesn't matter. But then compensation, are they going to take? Is it 10%? Is it 20%? Is it $2,000 per project? Or so it needs to lay out some specific terms. It's not really about what the figures are, but just the fact that there are specific terms in that contract that discuss, kind of the terms of your agreement. And then, if you go through an agent, in addition to the deal memo or some sort of a contract, you also need an itinerary of events showing the projects that you'll be involved with and what you'll be doing. If it's a TV show, let's say you get a role, it's going to be, let's say a better example would be a movie. So there's pre-production, then there's production, there's post-production, there's press that goes along with it. There are a lot of activities that are involved in that. So just because you're shooting, for a couple of days or for a couple of weeks, there are other things. Sometimes you have to reshoot a couple of scenes or something. So you can actually link those things together to show that it is going to last a little bit longer. So that would be included in the itinerary. You can add additional performances or engagements without filing an amended petition after it's been approved. So things change as long as when it was filed you thought and you were contracted for this production for whatever reason. Usually it's a money reason. The production kind of fell through, and instead you got this other job. Just because that specific production fell through is no longer on there, and you want to add something else, it doesn't mean you can't do it. So that's something just to be aware of. So the event, and the big question after who should sponsor me is, how long can you get? Technically, you can get up to 3 years. Again, if it's a full-time employment situation, that's just they're saying they're going to, hire you on, and you're going to be an in-house musician for this, jingle company for 3 years. That's one thing. That's a full-time job. But otherwise, they really are going to look at the itinerary that you submit and say, okay, he has a film, 2 films that he's, being brought on to write and rewrite and do, and maybe it's only 2 years. They could shortchange you and only give you 2 years. They could also approve it for the 3 years. It's kind of at their discretion. They've been pretty, I think, good about recognizing that things are, kind of spaced out a little bit, and then there are different activities that are involved in just one production, like what I was discussing: pre-production, post-production, promotional events. But you just want to include as much as possible. And again, if you have a gap, 1 month between events, that's fine, as long as you can string things together. Again, the nature of the industry is something that I like to point out. What's normal in this industry is different from a lot of other industries. Which brings me to advisory opinions and peer opinion letters. So this is the consultation requirement. So in arts, it should be from a national organization. So I have some examples here: AFM if you're a musician, VES if you're a visual effects. And then for TV and film, there's a management and advisory opinion required. So for the most part, anything in TV and film will require AMPTP, and then depending on whether you're a director, producer, actor, whatever it is, then you'll have the other, the labor union. So that'll be SAG, or now it's SAG-AFTRA. I should get used to that. SAG-AFTRA for actors, Directors Guild, and PGA for producers, and so on. And there's a published list. So it's very rare that you're able to choose It's based on your field, and the consultations actually cost money. So the fees range anywhere between $250 and $500. DGA, no, not DGA. I think the Writers Guild actually is one that does not charge. I think actually DGA also does not charge. So it depends, and it's, they have their own requirements, which, seem to change. But, and if no appropriate union exists, you can use a peer consultation letter. So, for instance, commercial producers, TV commercial producers, they're not necessarily covered by the PGA. So I've been fortunate, I just kind of dug around and I found an independent association of commercial producers, for instance. And so you can do it that way, or what you would do is get a letter from someone prominent in the field, like an expert in the field who would be able to provide a peer letter. My advice is always to check the websites. And if for some reason, and on the client side of things, if you get a call and your lawyer says, oh, no, sorry, but the, Directors Guild doesn't think you're, they're not going to give you a letter. They don't think you're qualified. Then, you can choose to try and argue with them, or you can submit anyway and argue that the consultation is not binding on USCIS, and our office has been successful in the past. So if anyone has run into that problem, we have done that. My advice to those of you listening who are interested in filing for an O1 at some point is to save everything. Anything that has your name on it, you should save. Whether you're going to use it or not, I think it's a good idea. If you're, any press is good press, in my opinion. Some people would argue with that, but at the very least you have it, and then it's easier to edit things out than it is to kind of go back and find things. And I talk to people all the time like, oh, I didn't know I needed that, or oh, I wish I had kept it. It's so hard to get, especially if some of those things are in your home country and they're hard to retrieve. I know with the internet it's pretty much possible to recover almost anything, but it's a good idea to save it, photos, invitations that you received, to play music at a music festival, or screenings, photos, those kinds of things you should always try and keep. So let's say you have your O1 and everything's going really well, and it's coming up on the expiration, the 3 years, and you want to file an extension, and you're happy with your, whether it's your agent or manager, you want to file an extension. There are two, basically there's if you file it as an extension without showing any new activities or new movies or anything, first of all, that's going to be a little bit hard. It used to be a lot easier. Now they tend to pick up on it, but you would kind of not automatically, but you submit everything, you meet the requirements, you've maintained your status, you've been working, you'll get a 1-year extension. If you can show a new event, or new activities or changes in the job, you can get an extension of 3 years. And there are some, there are some nuances that obviously we would help your attorney would help you with in terms of trying to get that 3 years. You could, for instance, travel it, or you could file it for consular notification, travel abroad to try and get the 3 years again. The O1 is great because there's no maximum on it. It is renewable indefinitely, but you do need to pay attention because, sometimes we'll request 3 years and they only give you 1, and, so you kind of have to be careful and you're constantly extending. You want to include as much updated information as possible, and then you want to look at the advisories. I know it's an added cost. So in the arts, for instance, if you're filing within 2 years of the last advisory, you can use the same one. In motion picture TV, they usually require new consultations or advisories, and I know they cost money because what they've done now is, for instance, AMPTP, they're very specific. They'll say we have no objection to so and so working for this company on X, Y, and Z productions. So then a lot of times, you're trying to file a new petition with, let's say, a different production company. So all of the projects have changed and the name of the company has changed. So in that respect, sometimes USCIS will want you to get a new one. Just a couple of small things for those of you who have had O1s. Possibly you might have had a problem if one. So let's say you file the petition, and generally this is how it goes. You file the petition. It's approved. You have to go to the consulate to get the O1 visa stamped into your passport, and you're ready to come back in and get to work. What has happened in the past is that the consulate, they say kind of, why are you so extraordinary? What have you done to deserve this visa? And really they're trying to re-adjudicate the petition, and really they can't do that unless they think that there's any sort of, they sent some sort of fraud or misrepresentation. They can't do that at the consulate. So it's pretty safe to assume, actually, you know what they say about assume. You can't do that, I know. But once the petition has gone through USCIS and it's approved, at the consulate, really they should just be asking you questions and figuring out, you are who we say you are, and that also you haven't had any other violations. So it's something to kind of, be aware of if you do run into problems. There's just another, subcategory for some people who don't quite qualify for an O1 yet. It's for amateurs, amateur entertainers, and it's if you want to come to the U.S. where, you want to perform in a social or charitable event, or you want to be a competitor in a talent, you want to compete in some sort of contest. It can't be paid, and so it's very specific, and I give the citation here. I'm more than happy to answer questions about that. And then obviously the last option, which we talked about earlier, was to use an O2. If, let's say, you are, like what we were talking about, that situation, you're an assistant director in the UK, and you've worked with this, particularly well-known director who recently came to the U.S. on an O1 to work on a film, and you're not quite there. If they want you to work on the film with him, you could be brought over as an O2. So also, likewise, if you're a production company and you're looking at those kinds of things, you can actually link a lot of O2s to an O1, provided that, and you have to show these several criteria, essential support. So the O1 has to, be in place, and then, and basically, and something else to note, the O2 is tied specifically to that O1. So if for any reason the O1 person, leaves or files for a green card or changes status or something else, the O2s that were linked to that kind of go away, and they'd have to, file their own petition. The O2s, you can file like 10 O2s on one single petition. You are required to get consultations for each O2, and I'm thinking in the entertainment context, where let's say it's a film and you want to bring the whole team. So you've got an assistant director, and then you've got cameramen and crew and hair and makeup and all these people who've all worked together before. You can put them all on one petition, but different consultations for each. And in this way, you would have to show that they've worked together. You have this long-standing relationship, or half of the film was, or half of the movie was filmed in Spain, and for continuity purposes, you're in the middle of filming, all this money and time, everything's taken place. You have to, the production is going to finish taking place in the U.S., so you need to bring over all of those exact same people for the continuity of the film. And you have to show that these people are essential, and for the most part, they're actually quite good about recognizing this. So that kind of concludes the O visas. I'll quickly touch on P visas because it really kind of it's not as much in the arts and entertainment. There are some bands and musicians that would qualify, or an entertainment group. So there's the internationally recognized athletes, or an entertainment group. It can be approved for up to 5 years, and 1 year for teams or groups. You have to show international or national renown, so it's even a slightly lower standard than the O1. So I've done this for, let's say, a boxer, or we've done it for musicians. There's like for a group, for a band, you just have to kind of show a few, the international renown, and you have to meet 2 of the criteria. And then there's the There's a reciprocal exchange program, and then there are also culturally unique performers. So let's say, you play a very unique instrument that's very unique to one country, and they want to, bring you over to perform here. This would be the perfect visa category. I'll go through the visa criteria for the P1 entertainment groups. At least 3/4 of the members of your group have to have had a relationship for at least 1 year. So, a lot of times new bands will come and ask to see if this is an option. So you have to make sure, you have that 1 year of playing together, that they're internationally recognized, and the reputation of the group is really what's important. And individuals who are not performing as part of the group are not eligible. So you'd have to be an O1. Culturally unique, I'll just touch on that again, to perform, teacher, coach under a program that's culturally unique. So the P visa is also a good option in case anybody is interested. You can ask me more questions about that. So this brings me to green cards. For most people in the arts and entertainment, again, the EB1 is what we call an alien of extraordinary ability. It's just kind of like the O1 criteria, but it's kind of like just a glorified O1. The criteria is very similar, but the standards are much higher and the adjudications are a lot tougher because it is self-petitioned. That they tend to look at them more closely, and then obviously more recently, since there's a case that came out, Kazarian, they have actually really, they're looking at things a lot more closely. Extraordinary is defined as a level of expertise indicating the individual is one of a small percentage who has risen to the very top of the field. And so they're really looking at just the top, the creme de la creme, the top of the top. And so, while it's difficult to meet that, a lot of times you don't realize it because if you have years of experience, you tend to have a lot of evidence. So it's a good idea to actually, look at it and evaluate it because it could be an option. One important point right here I forgot to mention, a lot of times people think, oh, I've been on an O1 for 3 years, or I've had 2 O1s or 3 O1s. Just because you qualify for an O1, it doesn't necessarily mean you're going to qualify for the EB1 automatically. It's a great stepping stone, and it's definitely an argument I like to make, to say that someone's qualified for an O1 means that they've obviously had some level of achievement, but it by no way is it to be, construed to mean that, I've had 3 O1s. 3 O1s equals an EB1. That's not necessarily the case either. So, basically for this category, it's EB1. So EB stands for employment-based, and there's employment-based 1 through 5, EB1 being the very top because it has the quickest processing times and it has the highest standards. You have to show the alien has to stay in national or international acclaim. And so, beyond that, the evidence, it's a lot like the O1. So you can have one-time achievement. So, you win an Emmy or an Oscar or a Grammy or, some huge award like that, or you have to show 3 of the 10 criteria. And here in my notes, I wrote, you have to heavily document the evidence and the source of publications. This is where they really want to see the circulation figures of the publication, of the press, how many hits does that website get per day. In terms of awards, how the awards are reviewed, how they're given, and how someone is recommended in terms of even membership. What are the membership criteria of that particular organization? Do they accept applications from everyone, or does a member have to nominate them, and what's the process? They really want a lot of detail, and I've learned the hard way, but Wikipedia is not a reliable source for this information. So you want to be sure to go to that company, if you're including information about, I don't know, I'm going to say like the Visual Effects Society, then go to the company, go to that organization's website and get information from there. Don't use second-hand internet sources as your source, like Wikipedia, because they say it's editable and it's not reliable. I've listed the criteria here in the tiniest of tiny print. There are a lot, it's prizes, memberships, again, publications, published material, whether it's about you or your work. For the O1, having the, reviews or the publications about your work or about, the film that you were on, maybe you're an animator and there's all this press about How to Train Your Dragon, for instance. That would work in an O1 context, but in a green card EB1 context, you do need slightly more than that. They do want to see that it's about you. So because, How to Train Your Dragon got a lot of press, so just by mentioning that, it doesn't really relate to you. But if you were interviewed, let's say, in some articles because you were this specific, you were the animator or the character animator for this specific character, and that was particularly interesting. That's the stuff that they're looking for in the green card. Judge of the work of others. So if you were selected, to judge a modeling competition, or if you were, reviewing, let's see, in the entertainment, like in a music, like, I mean, this is kind of crazy, but if you're like asked to judge an episode of American Idol, or something like that, that's the kind of stuff they're looking for in the arts and entertainment. Original contributions. This one's, it's, I think, hard because it's not as tangible as the others, but it's also great for the arts because if you're a musician, for instance, and you're writing your own music, that's a pretty original contribution. But the second part of that is of major significance. So maybe you wrote a, particularly original, like the album itself was original, and then the significance is that maybe it really, highlighted some things in that genre of music, or it kind of inspired imitation by other bands, so then that would be significant. So it's, I mean, you have to get a little bit creative, but it's also very specific to each industry and to each of, each individual, really. Authorship, so, if you've been asked to write any articles, that doesn't apply as much. Display of work at artistic exhibitions. This one they're really trying to limit, but arguably I would say, again, in like, let's say a music context, by performing at South by Southwest, that is a music exhibition. It's a music showcase for musicians. So I would argue that performing at South by Southwest, it would meet that criteria. So it's all about those little things. Leading role in productions and events, and then high compensation salary. I think those are pretty self-explanatory. You can also try and submit comparable evidence, which I forgot to mention in the O1 context. You are allowed to submit comparable evidence. You just have to show why the ones that are enumerated here don't apply. So you would just argue and say, look, I'm a musician. I don't write books and articles, or, something like that, and then you're able to meet them that way. The process itself, evidence and criteria aside, let's say everything's, going well and, you have everything. There are two steps. There's the I-140, which is the part of the application where you're describing and evidencing your extraordinary ability. That's where where all of the work goes in. Once the I-140 is approved, the rest is just kind of, you have to, then the second step is the adjustment of steps. So once you get the first one, hopefully that just means, that's the hard part. The rest is just your bio information, getting your medicals done, having your birth certificate, and filling out, the forms. And as long as you don't have, other issues, and by that I mean like immigration or criminal issues, or, any sort of fraud, that kind of stuff. I mean, obviously that would impede the green card process. But so in terms of the process itself, some people choose to file, I'm just going to check the next slide, choose to file both of the two steps together, EB1 and EB2, because once you file that second step, you get, within about 3 months, you get work and travel authorization. So that's attractive to a lot of people because then you're no longer tied to your O1 visa. It gives you a little bit more independence because you get what's called an EAD, an employment authorization document. So that's where some people prefer that. Conservatively, for me, if I see that the person, I think they're qualified for the EB1. I think they have a good case. But again, it's very, unfortunately, it can be very subjective. It depends on who's reviewing the case and which officer it goes to. But if for any reason that first step is not approved, the I-140 is not approved, if you filed the adjustment alongside of it, that employment authorization that came with that goes away. It kind of like dies with the petition. So I hate to use such a morbid word, but that's how it goes. So sometimes I like to split them up. We'll file the first one. Once that's approved, then we'll file the second step. But again, it just depends on your specific situation, and people, everyone has different needs and situations. So you can do that, but that's something that conservatively we do. And then what you can do, or what it does also, is it also saves the government filing fee. The government filing fee for the adjustment is about $1,000. So again, if for whatever reason the I-140 is denied, that second step is denied too, and you've lost that filing fee. So sometimes it makes sense to file them separately. But that's definitely, something that people can decide for themselves. Just some current issues, there is, like what I mentioned, there is some unpredictability. Unfortunately, it's a very subjective standard. What is, work for a distinguished company in my eyes is different from what it is in your eyes. I think that, I think Vogue magazine is a huge magazine, but maybe, a USCIS officer is like, I've never heard of that. So that's why a lot of it, when we talk about it, a lot of it is in demonstrating and evidencing everything. So just by saying something doesn't make it true. So just by saying you're the best doesn't make it true. You really have to try and evidence things as best as possible. And, likewise with the companies and everything, that's why it's good to over-document rather than under-document. That being said, I don't want to, we've been getting approval, so, they do also still go through, and we do have positive experiences, and I think a lot of people qualify that don't realize that they do qualify. Another thing people ask, should you appeal bad denials? In the past, I think it's been easier for people to, they'll get an I-140 denied, and what they'll do is they'll just kind of put it together a little bit stronger, a little bit new evidence, and then the second time it's approved. It's not necessarily that easy anymore, or that much, so I don't always, suggest that. Having said that, I did just file an appeal last year for a case that I thought it was, a bad denial. But sometimes it's worth it just to kind of rebuild your case and maybe give it a second shot in a year or two. And who knows? I mean, during that time, I always tell clients, maybe something will change. It only takes that one film to be nominated for something, or the box office numbers will come out, or in terms of in the animation industry, if that movie, again, I know a lot of people were waiting on certain movies. You want to see what who's going to be nominated for what at the Oscars. So sometimes it's a good idea to wait or to refile once you've had that one big break. I think I have some practice tips. Building the case. Need 3+ strong criteria and good evidence. We already talked about that. You want to really highlight the prestigious nature of the companies and the events and everything. And then you want, in terms of the localized evidence, I've had people, them pick on this. For instance, I submitted, some publications from Canada where I think it was the Toronto Star, which is, I think, the largest publication in Canada even, and they tried to pick on that and say that was they tried to call it a regional paper. Well, that's like calling the LA Times or the New York Times a regional paper just because the name of a region is. So anyways, sometimes you have to be creative, but that's not what I'm talking about here. What I'm talking about is, if it's a really small paper, like the circulation figures are really low, you want to try and, get more national or international press. And then there's Kazarian, which I'm going to talk to last but not least. Kazarian is a case that, it's just, basically from that case, there is now beyond the criteria we just discussed, there is a final merits determination. So there's kind of a second prong now where the officer, after he's reviewed everything, he looks to make sure that you've met at least 3 of the criteria. So let's say he's like, okay, yes, this person meets those 3. Then there's the final merits determination where they are supposed to now all of a sudden look at everything, consider all of the evidence all together, and ask 2 questions. One has, this person has a sustained national or international acclaim, and 2, that they are one of a small percentage who has risen to the very top. So, and again, from a lawyer's perspective, that is so subjective, which can be good and can be, bad. Sometimes when things aren't too specific, there's always a way to kind of argue, that this is sustained. They've had a long history. She's been working in this industry for 15 years, and so that to me sounds sustained. But, so that's where, when people talk about Kazarian, this is what the issue that comes up. There's the standard of review is preponderance of evidence, which means more likely than not. But it's something to definitely factor in and obviously discuss. Requests for evidence, they're very common. So if you're listening and you've gone through all of these things and you've gotten an RFE, it doesn't necessarily mean that it's going to be denied. That's quite the opposite. We get lots of RFEs and we respond to them and then they're approved. It's just don't give up. I mean, you just want to read it carefully, address all of the deficiencies that they raise, and really try and do your best to. And again, if there is an error where like I mentioned earlier, the Toronto Star being a regional paper, you want to correct them because sometimes they just say things or they haven't, maybe looked into it very much. So I would advise, correcting that, and then just really look at the evidence that you have. And just one key point. You can't submit new, so from the, if you get an RFE, you can't submit new evidence. There's a cutoff period. So if you filed it on May 1st, and then after you filed it, this awesome article came out in Rolling Stone magazine on like June 15th and saying like, this album is the best album I've ever heard. This musician, we've been waiting, for years. He's the, reincarnation of Jimi Hendrix or something. You can include it. I actually would probably still say to include it. But they can't really, it can't be added to the record. I mean, it's up to the officer whether or not he wants to even look at it. But, it can't be added, and you're not supposed to submit any new evidence. I'm going to quickly touch on the EB2 Exceptional Ability. I mean, it does apply to people in the arts as well as sports. But it does require a degree, and it also requires employer sponsorship. So in my, just in my experience working with people in the entertainment and industry, for the most part, the employer sponsorship is really difficult. But I've, listed the criteria here. For those of you who are, in visual effects, if you're animators, the SCAD A Group 2 is a great option because, again, for the most part, you're working for a studio, so you already have that sponsorship. And it is a lower standard than the EB1. The criteria are here, so you have to meet 3 of the, the ones listed. And again, it's all about the criteria. And again, by the way, all of this information you'll be able to find this at our website, but it's also on the USCIS website. If you go to uscis.gov, they list all of the criteria for each category, so it's always a good idea to look at that as well. Okay, I think what I'm going to do now is I'll try and answer. I don't know if I'm going to check right now to see if any questions were submitted, and I can answer a few of those. But if not, I do hope that you will email me, or, email is probably the easiest, I think, at this point. Please feel free to email me any questions, any comments, and if there's anything that I didn't cover that you're very interested in learning about. I do have a few questions here. I'll see if I can answer any of them. So this is a great question, I think, here about reality shows. What sort of visa would reality show participants, i.e. Italians in LA, need to get? That's a really, really good question. I've done some O1s for reality participants, and, you know, I think what happened is it's just kind of worked out, or like, you know, they've had some accomplishments in the field at home, so it's not someone who's brand new. We've actually, and I'm a part of a national committee, and we've actually been discussing what to do about reality TV participants and how they should go about. I mean, the B2 doesn't really work because they're being paid. So I don't know, it's one of those things where they're appearing on cameras themselves, and it's, you know, which comes first. So the reality show question, I'd love to speak with you. I'll email you separately about that. Let's see. Here's one. I read that the reference letters for a green card have to be written in part by people that you don't know, but they recognize your work. How would that work? I actually sometimes suggest that as well. Sometimes you know people, whether, you know, they're acquaintances or you've heard of their work, and somehow you have a connection with them, you know, through a friend of a friend or through an agent, where you would be able to get a letter from that person kind of saying, like, yes, I've heard of this person, I've seen his work, and I've, you know, read about him or something, and I saw his film, and in that film he had a particularly moving performance. And a lot of times it does come through your own personal contacts or through your agent, where people are, you know, you talk to them and they're willing to do it. So you should really explore your options. Let's see. I think the rest of them seem to be they're a lot more in-depth. So if you don't mind, what I'd like to do is possibly even conclude the webinar a little bit early. But I do want to encourage you guys to all email me and just do me a favor, and maybe in the subject line just say, you know, you're asking a question. You were a participant of the O1 webinar or the entertainment webinar, and I'd be more than happy to respond to you individually. And even if you don't have a question now, if down the line a situation arises and you do have a question, feel free to keep my contact information. You know, our firm is devoted exclusively to immigration, and then, you know, being in Los Angeles, we do have a lot of exposure to the arts and entertainment communities. And so I do want to go ahead and just thank you again for registering, and email me, contact me. You can follow us. I think I'm supposed to plug a little bit, but follow us on Twitter, like us on Facebook, sign up for our newsletter through our website, and you know, best of luck. I hope that this was information that you can use. All right, this concludes the webinar. Thank you, and I'll respond to the questions that you submitted through the chat function. I'll respond to them separately. Thank you.